everyone, and thank you for joining us this morning. My name is Kina Bernadette Dixon, and I'm the Marketing and Events Manager at the British Chamber of Commerce of the Philippines. I see we have a number of non-members joining us today, so just a brief intro on who the British Chamber is. So the British Chamber of Commerce of the Philippines is a non-profit membership organization and is the recognized voice of the British business community in the Philippines. The Chamber promotes its members' interest with government and business associations in the Philippines and in the UK in collaboration with the British Embassy Manila, the Department of International Trade, and other key partners. So if you're interested to join us as a member or collaborate with us, please feel free to email us at info@britcham.org.ph. All right, our sincerest thanks to our partner, Kittelson and Carpo, for collaborating with us and making this webinar possible. Just a few house rules before we start. Attendees' microphones and videos will be automatically muted and turned off so that we can focus on the speaker's presentation. We encourage participants to ask questions, and you may do so by typing it in on the chat box or using the raise hand function that you can find at the bottom of your Zoom screen. We will entertain questions after the presentation. And lastly, this webinar is recorded and will be shared to the participants after the webinar. All right, so let me introduce to you our speaker for today. She is a litigation and labor lawyer who has been a member of the Integrated Bar of the Philippines since 2014, specializing in criminal and family law. Prior to joining Carpo Law and Associates, she was an associate at Abellera and Calica law offices, where she gained extensive knowledge and experience in the field of litigation as the handling lawyer for civil, criminal, and administrative cases. Her focus was the prosecution and defense of criminal cases for violence against women and their children, adultery, estafa, medical malpractice, and corporate infringement, which included assisting law enforcement agencies in the investigation of these cases and negotiations for the settlement of claims. In the field of labor law, she is experienced at handling labor disputes and has assisted both the employees and the management on different stages, from administrative hearings to filings of pleadings before the labor tribunals. She graduated from the University of the Philippines College of Law with a degree of Juris Doctor in 2013. In 2008, she obtained her undergraduate degree in journalism from the College of Mass Communication of the University of the Philippines, Diliman. To discuss substantial issuances of the Department of Labor and Employment, updates on vaccination, duties of the employer, and compensation and benefits of employees, let's all welcome to the virtual floor, Attorney Greta Monica Trazo.
Hi, thank you for the introduction. I would like to thank everyone for joining us today, and I hope that we will be able to, enlighten you with some of the recent issuances of the Department of Labor. And I hope that we can guide you as we navigate our way through this pandemic, and so that we can continue our businesses. So let me just share my screen. All right. Okay, can I get a thumbs up if you guys can see my screen? All right, thank you. Okay, so again, my name is Greta, and today we are going to discuss how we can transition to the new normal. We are going to discuss the 2021 labor updates issued by the Department of Labor and Employment, vaccination protocols for employers, and employee compensation and benefits during the time of COVID. So first, we're going to discuss the 2021 DOLE issuances. This will cover department orders, labor advisory, circular, and memoranda. So for Department Order 221-1, this is the revised on issuance of employment permits to foreign nationals. This was issued earlier this year, January 6, 2021. Most of you, if not, I think most of the businesses now have foreign nationals that we employ in the Philippines. So recently, some of the periods for renewal were extended. And I think some of the fines for late registration have been waived. Imposition of quarantine protocols. So if you have any expats that you want to come to the Philippines to work here, you should take a look at DO 221-21 for the revised issuance of employment permits to foreign nationals. Recently, there was a labor advisory issued by the DOLE allowing for long-term stay of foreign nationals in the Philippines. And by long-term, it means more than 6 months. So AEP for long-term stay is more than 6 months. You should take a look at Labor Advisory 16-2021. 16-2021. Okay, it states there the rules that you have to follow. It's the Joint Memorandum Circular number 001, series of 2019, and Department Order 221, series of 2021. This one. Okay, so for DO 222 and DO 223, these are highly specialized industries. So if you belong to the following industries, you may want to take a look at that as well. So we have here an important department order. This is Department Order 224-21, which is the guidelines on ventilation of workplaces and public transport to prevent and control the spread of COVID-19. This was issued on March 3, 2021. So if you already have your employees working in your premises, you may want to take a look at the guidelines on ventilation of workplaces. So what does this have? So the guidelines on ventilation, there are general ventilation strategies and recommendations issued by the DOLE. It's different for non-air conditioned spaces, for air conditioned spaces, if you have exhaust ventilation, and it's different also for restrooms and water closets because as science says, COVID is spread through droplets. It's in the air. So these are the guidelines that you have to follow. I did not include here anymore the specifics because it's highly technical. So you may want to talk to an engineer. If you're renting your business space, you may want to talk to your landlord because probably they will have engineers as well who can help you comply with these requirements. So the ventilation assessment, qualitative and quantitative, is conducted by your safety officer. And your safety officer is in compliance with the Occupational Safety and Hazard Bureau of Occupational Safety and Hazards. So Safety and Health. So you must have your OSH committee. You have to be OSH compliant. So you have to have a safety officer designated for your company. And this safety officer will be the one conducting the ventilation assessment, qualitative and quantitative. Attorney, but our safety officer only attended the specific training to become a safety officer, depending on how many employees you have. If it's more than 50, if it's more than 100 or less than 10. So how is this person going to know what is the ventilation assessment? So you have to talk to your landlord, you have to talk to your engineer, just to make sure that you comply, because as I said, these are highly technical. So another question you may have is that, attorney, what if I'm the safety officer? What is my liability if we don't comply with this? So the safety officer is liable together with the company because, again, you were when you became the safety officer, you have this responsibility. You were given this responsibility, and you have to be able to comply with this responsibility. So as the employer, since you chose this person to become your safety officer, you have to give them support. So proper training and talking to professionals who know the details that are stated in the guidelines. Okay, so we also have DO 225 and 226. The first one is for the social amelioration for biofuel utilizing. So this is again a specific industry. If you belong to this industry, kindly take a look at this. And for DO 226, this is for the guidelines for the validation of polos, bipolos of the vaccination cards of OFWs. So if you are in the recruitment industry, you may also want to take a look at this. Now we go to the labor advisories. As I mentioned, we have Labor Advisory 16-2021, which provides for the issuance of AD for long-term, which is more than 6 months. For Labor Advisory 121, this is the waiver of penalties for AEP renewal applications. I mentioned this earlier. Advisory number 521, this is the transfer of all pending on-queue applications at the Oasis portal. So if you're part of HR, communicating with them, you may already know this, that everything has been transferred to the Oasis portal. Labor Advisory 621, this is the processing of camp for Bayanihan for the tourism sector, which ended just a month later on May 2021. So I hope you were able to, if you are part of the tourism sector, you were able to complete the application there. And other labor advisories for the payment of wages and the observance of holidays. So for those of you who do not usually check the labor advisories and you have questions regarding holiday pay, overtime pay, especially during holidays, paid non-working holidays, working holidays, check the the DOLE website, because they usually issue guidelines for the payment of wages for these dates. And this will be controlling. Even if you already have a policy in place, which is compliant with labor law, if that labor advisory says one thing, the labor usually you have to follow the labor advisory. Here, so Labor Advisory 3-21, this is the guidelines on the administration of COVID-19 vaccines in the workplace. 821 is the promotion of COVID-19 vaccination in the private sector. And 921 would be the Wear COVID form. So this will be the things that we will be discussing more in detail in this presentation, because of the vaccination campaign of the government. And I'm sure that you are also very eager to have all your employees vaccinated. And I guess there are a lot of questions swirling around regarding vaccination and being able to work. I think a few weeks back, there was a rumor running around that if you don't have a vaccine card, you can't get out of the house. If you're not vaccinated, you can't go to work, things like that. So those are the things that we will clarify today. So there is a joint advisory, but before that, we are going to go through all the issuances first. There is a joint advisory by the DTI and DOLE on March 9, 2021, which is just really a reinforcement of the strict implementation of the DOH Administrative Order 2020-15, Series of 2020. What is this? This is basically the engineering and other protections that they want you to do in the workplace. So for example, one way yung ikot ng mga tao, the movement of people is one way, the social distancing, where should disinfectants be placed, how often should disinfectants be used, things like that. So those are the contents of the DOH Admin Order number 2020 and the DTI DOLE JMC, Joint Memorandum Circular, Guidelines on Workplace Prevention and Control. Yung meron ba dapat cubicles, meron ba dapat partition, all of those are already included there. And then again, they are also strictly reinforcing DOLE Department Order 198, which is OSH compliance. So again, like I mentioned, the safety officer is important. So if you are, you have 10 employees, the requirements are different. Less than 10 employees. If you have less than 50 employees, the requirements are different. If you have 100 or more employees, the requirements are different. If you want to talk to me about being OSH compliant, you can email, or we can talk after this, so we can help you help you with what to do in terms of OSH compliance. Okay, so let's go to the meaty part of our presentation, of our discussion today, which is the vaccination. So from an employer's perspective, what are your duties to your employees? So rather than discussing it point by point, let's ask the most frequently asked questions regarding vaccination. No? So first, are employers required to procure vaccines for employees? It's yes and no. Employers are not absolutely required to be the ones to procure vaccines and give it to their employees. No, that's not required because the government is doing that. The government is procuring vaccines for everyone. That is the idea. So employers are not required to procure vaccines. But I'm saying yes and no because employers are required to have a vaccination policy. So Attorney, what's a vaccination policy? Do we need to have them vaccinated? Do we need to accompany them to the vaccination centers of the local government units? No. All you have to do is to have is to state what is your policy on vaccination. I'll discuss that more in detail later on. So under Labor Advisory number 3-21, covered establishments and employers shall adopt and implement the appropriate vaccination policy in the workplace. Establishments shall endeavor to encourage the vaccination of employees. So employers are actually encouraged to tell your employees, and covered establishments may, as I've said, may procure COVID-19 vaccine supplies and other services. So if your company has resources and they're able to procure vaccines for your employees, that would be great. And you can actually do that. You can vaccinate your employees. Under Labor Advisory 821, all employees in the private sector, except those ineligible or disqualified for health reasons, are highly encouraged to be vaccinated. So again, you take a look at the language of the law. It says highly encouraged to be vaccinated. So employers are to urge their employees to avail of the company's vaccination program, if any, or their respective local government units. Seek appropriate assistance from concerned government agencies. So let's discuss what is a vaccination policy. A vaccination policy is basically just a statement by the company of how you will assist your employees with regard to their vaccination. It's either the company will procure your own vaccines. If not, then the company may give assistance in terms of registration with the LGUs. For example, most of us are part of the A4 category. And in Makati, before you can register with for the vaccination, if you're A4, I think you need to indicate therein that you are A4, and then the companies are all listed down. So maybe your company can write a letter to the Makati local government unit and state that these are the number of employees that we have. They are A4. A certain number of them have already been vaccinated, etc. These are the ones that are not vaccinated. Those are the things that you can do. Another thing is you can give them assistance in terms of registration with the LGU by giving a certificate of employment or just being able to coordinate with the local government unit when the vaccination can be done. Included in the vaccination policy would be the point person. To whom should you, for example, you have 100 employees and you can 100 employees and most of them probably have comorbs or have already been vaccinated. You have to keep tabs on who are vaccinated and not. No, so you can require your employees to tell you if they have been vaccinated or not. And they have to report that to you because you are monitoring it. Okay, so you should designate one person or at least two, depending on how your company structure works. But you have to have someone that people can tell, hey, I'm vaccinated. Okay, or hey, I need help registering for vaccination. Okay, so who bears the cost of vaccination? It's the employer or the government, because Labor Advisory number 3-21 says that no cost of vaccination in the workplace shall be charged against or passed on directly or indirectly to the employees. Labor Advisory 18-20 also says that no cost related or incidental to COVID-19 prevention and control measures shall be charged directly or indirectly to workers. So, question, Attorney, what if our company is so generous, they're allowing us to have one dependent be vaccinated as well, but they're saying kasi that we have to pay for the handling, for the storage of the vaccine. So employer cannot charge you for for your vaccination and for the cost of your vaccination, but the employer can charge you for the vaccination of your dependent. Okay, because this is already what the labor advisories contemplate is the vaccination of the employee. So it goes already beyond. No? Can you guys hear me? Okay? Can I get a thumbs up if everything's fine? I got a prompted. Okay, great. Thank you. Okay, great. So again, as I said, so for your vaccination as an employee, no cost. But if it's extended to your dependents, into your family members, then there can be such charges. Okay, so the other one is, can an employee refuse to be vaccinated? As of the moment, yes, you can refuse to be vaccinated. This is confirmed by DOLE and is in line with the constitutional right to health and to privacy. But attorney, bakit hindi natin sila pwedeng bakit hindi natin sila pwedeng mag-vaccine? Ayaw nila mag-vaccine, tapos makukuha nila yung COVID, tapos pupunta sila ng ospital, tapos agawan pa nila yung iba, kasalanan naman nila, hindi sila nagpa-vaccine. Right? So there is a delicate balance there between your right to your privacy, the right to choice, your constitutional right to do what you want with your body, and you have to balance that with the overriding public policy and safety. So can you force someone to be vaccinated so the public can be protected? There is no well, right now, as of this moment, you can. So the constitutional right to privacy and to health is still overrides the public policy. But there is no Supreme Court case yet, and I'm yet to see it. I've yet to see it, and actually curious how the Supreme Court will rule about this. So, but there's no case yet. So right now, yeah, as of the moment. Here, can an employer terminate an employee who is COVID positive? Generally, no. Generally, no. Especially since Article 284 says that, especially since that, sickness, as stated in Article 284, has to be something which prohibits the employee from coming to work, to returning to work, or is prejudicial to the health of everyone. But attorney, if you have COVID, you will prejudice everyone if you show yourself to work. I agree. But then again, generally speaking, COVID has a healing time. So you have, sabihin na natin 2 to 3 weeks recovery. So after 2 to 3 weeks, you're no longer COVID positive, and you no longer pose a threat to your office mates. So it's not a basis for termination. But for example, wag naman an employee becomes COVID positive, and then it's a severe case, and then the employee recovers, is still alive, but for example, the lungs are so damaged they can't walk, or they can't, they're so weak. Can you terminate them? That is a very delicate question, and it's a fine line that you have to tread for you to know if it's already time to terminate an employee. Attorney, 6 months na siya hindi pumapasok, lagi sinasabi hindi siya makahinga. Paano naman yun? Well, one thing you can do is, diba, no work, no pay naman. So, hindi nag-work si employee, hindi siya nababayaran. So, you just keep them in the payroll, they're still employed. But the problem is they are also earning tenure. Diba? So, it's a delicate balance. What can we do, attorney? I think it's best for you to require employees after they get sick, not just COVID, but any sickness, is to require them to get a medical certificate from a doctor or a public hospital, or one of your accredited hospitals or clinics, for them to get a certification that they are fit to work. Why? Because if the certification says they're not fit to work, you can't force them to work. And it depends on the type of sickness that they have and the certification that they have. You can also terminate them on the basis that, well, they can't work anymore. So like this one, whose continued employment is prohibited by law, is prejudicial to his health. So you know what to do with your employee. Another thing, if the certification says that they are fit to work and they keep telling you, I'm sick, ganyan, I can't work, then you can start with your disciplinary measures. Okay, but then again, this is a case-to-case basis. All right. I think the good rule of thumb when it comes to this is good faith. Good faith. You have to do everything in good faith, and you have to do everything above board. Okay. Ito na. Can an employer require vaccination for continued employment? Dami nating nainig na chismis about this. No. No vaccine, no work policy is absolutely prohibited. If you take a look at the language, it's absolutely prohibited. Bawal na bawal na bawal na bawal. Parang yung warning sa Annabelle, positively do not open. It's like that. Absolutely prohibited. Under Labor Advisory 3-21, an employee who refuses or fails to be vaccinated shall not be discriminated against in terms of tenure, promotion, training, pay, and other benefits, among others, or terminated from employment. No vaccine, no work policy shall not be allowed. Okay. So, attorney, question, what if we have this unvaccinated employee who refuses to be vaccinated? So, hindi siya pumapasok sa work. Of course, magpapadala kami ng field personnel. For example, you're in the business of sales and you send out field personnel. Eh, syempre, attorney, gusto namin yung ipapadala namin yung vaccinated. Kasi syempre, problema pa pag nagkaroon ng severe COVID case, one of our employees. So, hindi namin siya kinukuha kasi hindi siya vaccinated. Pwede ba yun? Case-to-case basis. Again, case-to-case basis. It depends on your purpose, and it depends if you can show good faith, and if you follow process. So case-to-case basis. Best to consult with a lawyer before you do anything. It's a case-to-case basis. Madalas sa labor cases. Okay. Can an employer require that they be vaccinated before returning to work? Baliktarin naman natin. Paano pag si employee ang sabi, what if the employee asks to be vaccinated first before you issue a return to work? May pasok na tayo ng October and they said, pa-vaccinate nyo muna kami bago kami pumasok. Can they do that? No. As long as the industry is allowed to operate and there are sufficient safeguards in place in complying with OSH and DOH standards, you can compel your employee to come in, even if they demand to be vaccinated first, or even if they demand, for example, a shuttle, or if they demand so and so long as you are complying and you are allowed to operate and it is within the workforce capacity allowed by the law, allowed by the alert levels, allowed by the IATF, you can force your employees to come to work. The WARE form. So I just wanted everyone to be aware that starting April 30, 2021, employers are strongly advised to submit online the monthly workplace COVID-19 prevention and control compliance report, which is a WARE form. through the DOLE establishment report system. So yun, di ba, may RKS form if you have movement or projects na natapos or nag-redundant or nag-retrench, kailangan nyo din mag-report kay DOLE every month, end of the month. Yung health report ninyo, what does this state? Well, every 30th of the month, mag-submit ka, we have some so-and-so employees, so-and-so employees were sick, a number of employees were sick, a number of employees were not. With or without any COVID cases, you need the report. Kaya sinasabi ko din kanina, in your policy, it's good to have a POC who will monitor everyone then. And I think it's part of your duties as the employer, as included in the Joint Memorandum Circular and in the DOH compliance orders. Okay, so we go now to the compensation and benefits of employees. So one thing that most employers are now considering is the restructuring of employee compensation and benefits, especially if business is not good or you want to be able to keep all of your employees, but keeping them all would be tantamount to more losses and you won't be able to sustain the company. So let's start with the general rules. The general rule is that an employer cannot unilaterally take back or reduce benefits granted voluntarily to employees. Benefits already granted as stated in the contract or has been practiced for a long period of time, consistently and not as a mere error. Yan. So alam to ng halos lahat ng empleyado, non-diminution of benefits. So tuwing may mariinig na parang magbabawas daw ng sahod or non-diminution. You're not allowed to reduce, you're not allowed to take away. And that's true. That is true. The employer cannot unilaterally, on its own, the employer alone cannot take back or reduce benefits granted to employees. These are benefits granted in the contract or has been practiced for a long period of time. Okay, long period of time, company practice. Adoption of flexible work arrangements shall in no case result in diminution of existing benefits. So, kung for example, you have 3 days work na lang, hindi dapat nababawasan yung benefits. Paano yun? So, ibig ba sabihin, kahit di siya pumasok, for example, meron siyang de minimis which is granted on a daily basis, kailangan bigay ko pa rin ng buo kahit hindi siya pumasok ng buo? No, not like that. What I mean is, hindi mo pwedeng i-reduce yung amount, but if they earn it daily, then they earn it daily. If they earn it monthly, they earn it monthly. So, kung nababawasan yung de minimis niya, pag nag-absent siya, pag hindi siya mapasok, pwede mo din siyang i-reduce. Sorry, I forgot to say something. What is company practice? What is practice for a long period of time? Company practice, usually, kailangan matagal na siyang ginagawa ng kumpanya. At least 5 years. And hindi siya out of generosity lang or hindi siya out of error. As in, ginagawa talaga siya for a long period of time. Which means it has ripened to company practice. What is an example of that? For example, is the annual increase in your salary. If annually for the past 5 years, nag-i-increase the company regardless of its performance, that will ripen to company practice. At paano naman yun kung okay lang naman talaga kasi yung business, kaya kami nagbibigay ng benefit for the past 5 years, hindi dahil gusto namin siya maging company practice. How do we stop something from becoming company practice? So for employers, what you do is whenever you grant a bonus, you indicate, you state on the record that this is being granted because of so-and-so reason, and shall in no way be construed as company practice. So i-state mo lang din, hindi ito magiging company practice. Always include that whenever you grant bonuses. Or kung hindi siya nakalagay sa kontrata, if it's something above and beyond. So this will not ripen to company practice. Okay? Okay. So we have here an interesting labor advisory 17-20, which is the guidelines on the employment preservation upon resumption of business operation. This was issued because what DOLE wanted was, instead of employers terminating employees, so you restructure na lang, you have flexible work arrangements, or you reduce the salaries during the quarantine. So actually this was allowed because Labor Advisory 1720 applied to all employers and employees are operating or allowed to resume business during quarantine arrangements. Remember, during quarantine arrangements. So far, we are always naman in quarantine arrangements. So this is still allowed. Flexible work arrangements, work from home schemes, alternative work schemes, these are allowed. All of these are allowed, provided that there are reporting requirements. You have to report everything to the DOLE. But in terms of the adjustment of wages, if you look at 1720, which was issued last February, I think last year, if you take a look at your Section 5, employees and employers may agree voluntarily and in writing, so hindi siya unilateral, no, to temporarily adjust wages and wage-related benefits for a period of 6 months, which they can renew after that. So medyo nung grinanto, yung 1720, medyo that was a good leeway for employers to be able to negotiate with the employee for example, a reduction of salary or for the removal of certain benefits for a certain period of time, which is only 6 months, which can be renewed. Kaya lang, what was issued was Labor Advisory 1720B, which now removed this section and replaced it with this. Transfer, assignment, job rotation, reduction of work days, partial closure, and other work arrangements, including adjustment of wage and wage-related benefits, shall be governed by existing laws, rules, and so technically hindi niya tinanggal, but it says shall be governed by existing laws, rules, and regulations. So what is the existing law, rule, and regulation? It's non-diminution of benefits. We go back to the general rule, which states, which states that an employer cannot unilaterally take back or reduce benefits. So tinanggal ba talaga o hindi? My view with this is that you cannot unilaterally, but what you can do is you can have a discussion with your employees and find common ground. Yeah, here. So can an employer and employee still enter into an agreement for wage adjustment? It depends. It depends. You have to remember non-diminution versus the voluntary nature of agreements. So if you talk to your employee, be candid, open up with them, guys, we can't continue with this. If you are willing, let's do it. And then once business picks up, we can resume again. But you can't force the employee. Okay, so we've seen this happen. For example, we know of a company who offered to their employees because of COVID, they offered the employees that, well, they are a BPO, receiving calls from clients. It offers employee, if you don't have any calls for today, you can come in. I'll pay you for the hours you're in, but if you don't receive any calls, you can go home, but you're only paid for that amount. So hindi finors. No, it wasn't mandatory. The employees were given a chance. So the employees, of course, chose to be paid the whole day. Who wouldn't, diba? Eventually, it ended up that they had to reduce personnel. So, and it was explained to the employees. So it's best to be able to talk to your employees and be frank with them in terms of where you are financially as a company. So voluntarily, if it's voluntarily entered into, no problem. But attorney, so pumirma naman siya, so voluntary yun. You have to remember, there is an inherent imbalance of power. Diba? Pag si employer nagsabi, do this, the employee, can you negotiate? For example, if you're an executive, of course you can negotiate. because of the position that you hold. But for example, if you are rank and file, lower in the corporate ladder, you don't have as much bargaining power as the ones on top, or as the same. You don't have the same bargaining power as the employer, which is why actually our labor laws usually favor the employees, and because of this inherent imbalance in power. So my suggestion would be to conduct everything again in good faith, and to take all of this into consideration. And just remember, you may enter into a wage adjustment agreement, but it has to be voluntary, and you have to inform people. Another question. Attorney, can we restructure the salaries of our employees? It depends. For example, you can restructure for if you see now that this current structure is not working, it's too much for your current employees, and you want to lower it, you can lower it for their new hires, for your new hires. There's no problem. So long as there is no salary distortion, you can do that for your new employees. But for your old employees, the ones who have been there, again, like I've said, it has to be with their consent if it is a reduction. If it is a reduction. So, for example, your employees are receiving allowances, but they're having trouble giving you receipts to liquidate or to justify the allowances. So what you wanted to do is to turn the allowances into basic salary. Pwede ba yun? Can you do that unilaterally? Yes. Because hindi naman bumaba yung basic salary mo. There was no change. But syempre, the tax consequence will change. So you have to top it up. So kung ano yung tax nun, masasagot niya. Basta the net pay for the employee is the same, it's fine. What if attorney tataas yung net pay niya? Kasi basic pay, babawasan natin, gagawin nating allowance, not taxable. Pwede ba yun? No. Because that's already a basic salary. You cannot reduce the basic salary. Okay? This one. What about bonuses and annual increases, attorney? Can we opt not to grant it? Well, if it is stated in the contract and it's guaranteed, you have to give it. So some contracts are guaranteed 14, 15, 16 months and guaranteed annual increase. Kailangan nakalagay. You have to give it. But if it says in your contract that annual increase or bonuses shall 15th month shall be granted, provided the company reaches a certain amount or the company performs well, etc., then you take a look at your finances, and if you're able to justify that you will not be able to grant the bonus or annual increase, then it's fine. Okay? So I think that's the end of my presentation. I hope you have some questions for me.
Hi, attorney. Thank you so much for that very comprehensive presentation. We do have a few questions in the chat box. So let me start with, so this question is about foreign nationals. So earlier you said that expats now can enter the Philippines. So this is just a follow-up question. So can expats enter the Philippines and apply for 47A2 visas?
Okay.
At the moment.
Okay, I am not familiar with the exact numbers of the visas, but they can apply because as stated in the DOLE requirements, you just have to comply with the documentation. I think you can send me an email to the person who asked this, because we do have a visa services department, so we can assist you with that. I can get you in touch with them, so we can get in touch with them in terms of this. Yes.
All right, thanks for that, attorney. And a follow-up question. So since visas are now, since foreign nationals are now are granted entry to the Philippines, so does that mean any type of visa? So 9A, 9G, working visas, temporary visas, is that allowed entry now to the Philippines?
It depends on the nature of your visit, no? So usually sometimes CBI kasi is requiring may iba pang requirements kasi CBI eh. And it depends kung saan galing yung foreigner mo. So sometimes we're not letting in people from, I think, Indonesia and India. We're not letting foreigners in from those places. So it depends. It depends, no? But definitely for AEPs, those who are going to work, pwede na silang pumasok.
Okay, got it. Thanks, attorney. All right, and then the next question is this is in line with your statement earlier that on the termination of the employee. So if we can terminate an employee due to health, do they need to pay separation pay?
So it's not okay. So if you terminate an employee due to health, it's just cost kasi, not authorized cost. So remember, ang authorized causes mo, you have to pay a certain amount if it's redundancy, retrenchment, etc. So no need for separation pay. Kasi hindi siya, it's for cost. It's for just cost, not authorized cost. But it's best to still give at this point. Yeah.
Okay. Thanks for that.
I can send that that person can directly email me. I can send her the requirements for termination due to health.
Okay, great. Thanks for that, attorney. And then the next few questions are on the where form. So if they are in a work from home setup, are they required to accomplish this form?
Yes, even if you are on work from home, there is no discussion in the labor advisory that it has to be face to face.
Okay. All right. So attorney, just a follow up on that as well. So the form should be submitted. Is it mandatory for all companies to submit that?
Yes.
Okay. Okay, great. And then another question, is it reasonable to subject an employee to a disciplinary sanction, for example, suspension, in giving untruthful information or falsification or of health declaration form? And who will be the complainant if this will be categorized as administrative case?
Yes, you can discipline an employee for being dishonest in their health declaration form. Number one, because this is serious dishonesty, serious misconduct, because this relates to their duties. It's the duty of the employee to inform the employer of their current health standing, especially since COVID is highly transmissible and can be fatal and can affect the business as a whole. So you can discipline the employee, be it suspension, be it termination, whatever for example, if he infected the entire office, it's grounds for termination. But again, you can exercise compassion and do suspension. The complainant here is the employer, because they put in danger everyone else. And again, also, may I remind you that there are requirements under certain laws that for you to disclose properly and not to lie on your declaration of in your health declaration forms. Just a friendly reminder, you should not lie.
Thank you for that, attorney. So the next question is about allowances. So what if they introduce like a new allowance scheme if for the next 2 quarters in support of return to the office, and then they had it removed or reduced after 2 quarters? But they were advised, like the employees were advised upfront. Is that okay? Is that possible?
Yes, just put it in writing. Just put it in writing that this is not an additional benefit. This is something for that this is mere generosity. This will not be a permanent benefit. This is financial assistance, and they have to sign off on that.
Okay.
Para lang malinaw. Just lay everything should be in writing, guys. Everything should be in writing.
Okay, great. All right. This one, attorney, is on the return to the office. So the question is, what if NCR office is OSH safe? Employee has moved to a remote province since COVID. We ask all staff to come in 5 days per month. their manager is happy to come to the office for one whole week per month rather than weekly to be flexible for employee. What if the employee still says that they do not want to come back to the office? Can the employer take action?
Yes, you can. First, issue a return to work order. If they don't return on the date that you ask them, then that would be grounds for disciplinary action.
Okay.
Basta OSH compliant. Basta OSH compliant.
What if, attorney, if the company is not like is lax when it comes to safety compliance in the office? Is the employee allowed to negotiate like other work arrangements for that?
You can negotiate. It depends on the stand of the company. If the company thinks they are compliant and they're not, then it's up to the up to the employee to prove that they're not. It will go to court, but you can always negotiate. You can always negotiate. Yes.
Okay. All right. Thank you for that, attorney. And then this one is a direct message. So it's about the performance improvement plan. So is it legal, and if it is binding with our existing labor code?
Actually, the PIP is legal. It's legal, it's allowed, because it gives the employee another chance before ma-issuehan ng NTE. So, PIP first, and then saka pa lang yung disciplinary proceedings. But if the PIP is the only basis, so long as the PIP, the notice of PIP, the notice you're being placed on PIP is compliant with the twin notice rule, it's fine. But usually it's PIP plus yung NTE notice of decision. It's compliant.
Okay, thanks for that, attorney. And then for the next question, sorry, we have a lot of questions for you today. So the next question is, how far can you penalize absences without pay, especially if the reason is not feeling well or just saying that they have COVID-19 symptoms?
It depends on the risk appetite of the employer. But basically, what you do is you always require documentation. You require proof. For example, the employee showing symptoms, etc., etc. After 5 days from when you ask when they first started with their symptoms, and then on the 5th day from that, have them take a test. Have them take an antigen test or RT-PCR, just so they can prove that they really are COVID positive. You can always require proof. Requiring proof is the best defense of an employer. And then again, even if this goes to court, like I keep saying, if this goes to court, though the employers have a sympathy card, especially if they're gonna say they have COVID or someone has COVID, because we can all relate. You can all relate and empathize with that. So the thing that you can do as the employer, if you're part of HR, is to always document and ask for proof. Yeah.
All right, thanks for that, attorney. So just a follow-up question on that. If ever like the company has no like testing or like testing schemes, COVID testing schemes, and they require employees to return to the office, is this a ground for labor violation, or are the employers allowed to ask the employees to go back even without COVID testing?
Even without COVID testing, you can ask your employees to return to work. Again, the only thing you have to do is to check, are you allowed to operate? 2, at what capacity are you allowed to operate? And 3, are you compliant with the requirements of DOLE and DOH? If you are complete with that, you can require your employees to come in.
All right, thanks for that, attorney. And then the next question is, if the employee's job role changes due to the restructure and the salary of the new role is lower, can the salary be decreased?
No, non-diminution in rank or in salary. So promotion in rank or movement in rank, but lower in salary, not allowed. Unless, of course, it's not unilateral, but generally speaking, not allowed.
Okay, thanks for that. And then for this one, the next one is, we are in the maintenance service agreement. Our client require that the employees we send should be vaccinated. What if some of our employees refuse and we cannot deploy them to other clients? Can we not pay them their salary? Can this be the basis of disobedience under the company policy?
Complicated question. Can you say it again? Sorry.
I think they are in the maintenance service agreement. So they deploy employees to certain clients. So what if the employees their client requires the employees to be vaccinated? So what if their employees refuse and they cannot deploy them to these specific clients? Can we not pay them their salary? And
Yes,
can this be
yes.
the basis of disobedience under the company policy?
Okay. So two questions yan eh. Can we not pay them their salaries because they're not working? Yes. Because they're not going to it depends on the type of payment scheme that you have. But if hindi sila nakakapunta, kaya hindi sila nababayaran because the client is requesting a vaccinated employee, you're not naman requiring them to be vaccinated to work. It's the client who's requiring them to be vaccinated before you can send them to work. They can still work and you can still send them to clients who are requesting that the employees who have no request na the employees are vaccinated. You can send them there. So there's no discrimination. Okay? So you can reduce their salaries. But is their refusal ground for termination? I don't think so. Okay? As mentioned in the labor advisories, refusal to be vaccinated is not ground for termination. Kung gagamitin mong dahilan yung hindi kasi sila nakakapunta doon kasi they're not vaccinated, well, it's not their fault as well na walang clients na gusto ng vaccination. So I don't think they can be terminated. Very thin line yung iwawalk mo dyan para ma-terminate mo sila. Don't terminate them, but pwedeng no work, no pay.
Okay, thanks for that, attorney. And then for this one, this is on holiday pay. So going back to the holiday pay, is observance of local holidays. Is observance of local holidays, for example, Pasig Day, considered a management prerogative? And if so, can we change our practice on observing local holidays since they have 12 sites nationwide?
It depends. If the local government says that it's Pasig Day, no work today, you have to follow the government na no work today. So you can always change your policy basta hindi magbabago yung pay. So long as yung observance, if you're going to observe that holiday, usually naman walang additional pay for those local holidays unless the government says so.
Okay, great. Thank you for that, attorney. We have a few other questions here. Okay, so are there any recent changes to OSH rules related to COVID from DOLE or DTI or any other body?
No naman, just take a look at those things that the ones that I stated in the slides. You can take a look at that. Those are updated.
Okay. Down to the last two questions, attorney. What is the responsibility of the ER if the employee refused to be vaccinated, then got infected with COVID while at work?
Sorry, can you say the first part? Sorry.
What is the responsibility of the employer if the employee refuses to be vaccinated, then got infected with COVID while at work?
Wala. Wala. There is no liability on the part of the employer, but the employer has to be ready to prove that they are compliant with the standards required for the operation. And again, you cannot pinpoint and determine where you get COVID. Diba? Unless ikaw lang ang lumalabas at isa lang ang pinupuntahan mo, nakakotse ka, wala kang ibang nakasalamuha, like diretso naka-vacuum ka diretso office. You can't say where you got COVID. You can't. Especially if you live in a household where people are going in and out. You can't. So the employee has to actually prove with scientific evidence that I got COVID in the workplace. That's not. It's difficult to prove for the employee.
Thanks for that, attorney. And the last question here in the chat box. If the company adopts different working schedule in line with labor advisories and telecommuting act, will reporting to DOLE suffice following the guidelines therein? will there be other considerations or steps to follow?
Reporting is fine. And of course, compliance with the non-diminution rule, just compliance in good faith, but reporting is fine. Yes.
Thanks for that. Sorry, attorney, we have another question.
Go ahead.
Can an employer offset holiday to another day? So for example, holiday September 22 and offset it to September 25.
Okay. Yan. That is the issue. It depends kung managerial or rank and file. For managerial, pwedeng pasok ka yung holiday, next week ulit na pumasok, that's fine. Okay lang yun, managerial employee sila. But not entitled to holiday pay. But for rank and file, you can't do that. Why? What is the reason for that? Because holiday pay has a different rate. Has a different rate to it. If you work on a holiday, you have a different rate. As opposed to you work on the 25th, hindi holiday. Kaya iba yung rate. So, hindi pwede. Unless bigay mo pa yung holiday rate for this day. Huwag ka mag-holiday today. Ibang araw ka na lang mag-holiday. Pero yung pay mo is as if nag-holiday pay ka. Okay lang yun.
Thanks for that, attorney. Just a follow-up question on the responsibility of the employer. If it was proven that the employee was infected while at work, for example, deployed at another venue for a client, would the employer now have more responsibility?
No. So long as you give them proper safeguards. Kung compliant ka, you're allowed to practice, you're allowed to operate. Tapos you have you supply them with the necessary gear. Binigyan mo naman ng PPE, binigyan mo naman ng face shield, ng face mask, ng gloves, ng Lysol, ng wipes. Ginawa mo naman lahat to protect the employee. Not your fault. But if the employer does not have sufficient safeguards, then the employer can be held liable. Not under, both under DOLE and for civil case for damages. Or takutin natin ng konti, criminal case for negligence, reckless imprudence. But very, very far off na yun. Very, sobrang legal gymnastics na yun. But you can be held liable if you do not comply with the requirements of law.
Thanks for that, attorney. So another question. So does NLRC always accept all complaints without review and order an employee to explain? In accordance with labor advisory, that suspension of business operation is not included in the 6-month probationary period. Terminated probationary employee filed complaint in NLRC. Can you question or file complaint against the NLRC?
I think I get your question. I think the first question that you have is, talaga bang si NLRC kahit anong complaint, kahit hindi naman sila dapat mag-complain, tinatanggap? NLRC has no, the NLRC, the DOLE, the SENA level first the SENA has no discretion kung tatanggapin niya o hindi yung complaint. What they are required to do, it's ministerial. If someone complains, they accept the complaint, they send the summons to the employer, and they make them harap each other. NLRC has no choice. It's a matter of being able to prove your stand. The employee has to prove that they were illegally dismissed. Employer has to prove that they were legally dismissed. And dun sila magbabangga. Kumbaga, venue lang. Kumbaga, ring lang si NLRC. Wala siyang choice. Kung sinong gusto maglaban dyan, maglaban kayo. Yung probationary employee, kasi nga nag-issue nga ng, I think this also happened to one of my clients, or I think one of another client, lawyer's client, who consulted with me as well. What they did was, there is a probationary employee, and then the DOLE issued na hindi kasama yung 6 months in the probationary period, and then nag-issue na naman sila na kasama pala. Parang something like that. Medyo malabo kasi yung issuances ni DOLE regarding the inclusion and non-inclusion of the 6 months period. So it's a case-to-case basis. Maybe we can talk more in detail about that, but it depends. What I'm trying to say is that you can always go to the NLRC to file a complaint. Hindi mo pipigilan yan. But the best you can do is to always, as the employer, is to always document everything, have everything in writing, so that you are, so that you have evidence of what you did, and defend yourself before the NLRC.
Thanks for that, attorney. And then another question, are there any laws over OSH in the home if hybrid remote not 100 if the work is hybrid remote and not 100% telecommuting?
Yes, meron pa yan. Meron pa yan. I think, kasi ang mangyayari dyan is that ano bang capacity, you will still take a look at what is the capacity of the office. Even if you're hybrid 100, pero ano bang capacity ng office mo? Ang capacity mo ba 30? Ang capacity mo ba 50? It depends. It depends sa capacity also ng office mo.
All right, thanks for that, attorney. And we're down to the last question.
Yay.
So, is there an additional pay required for employees who go outside, for example, PEZA or government offices? Hazard pay. She's talking about hazard pay.
Company policy na yan. Yung hazard pay. Very, very, ano kasing hazard pay, very specific in terms of industry, yung hazard pay. So, pwede mong i-grant yan. Pwede mong i-grant kung gusto mo as an employer, but not absolutely required depending on the industry.
Okay, all right. So that's the last question, attorney. Thank you so much for answering all our questions today. If you have other questions for all the attendees, if you have other questions, please feel free to email us, and we'll coordinate with Attorney Greta and her team so that she can assist you further on your inquiries. Again, thank you so much, attorney, for spending your morning with us and for answering all our questions today. Thank you so much to Kittelson and Carpo for partnering with us. It is definitely a relevant and great conversation, most especially during this trying time. Again, if you have questions regarding the presentation or more info on the services of Kittelson and Carpo Law, please feel free to email us at events@bridgeham.org.ph and we'll introduce you to their team. We would like to remind everyone that this webinar is recorded, and if you want a copy of the recording as well as other webinar resources, please email the BCCP events team. Again, thank you so much, Attorney Greta. Thank you so much to Alex for helping coordinate with us on this webinar, and to Kittelson and Carpo. To keep updated on the latest news and our upcoming webinars, please visit our website, bridgeham.org.ph, and our social media sites. If you're interested to partner with us for a webinar, please don't hesitate to email our events team. Again, thank you so much for participating in our webinar today. We hope you find this useful and relevant. We have a lot in store for everyone in the remaining months of 2021, and we look forward to seeing you in our next training and webinar sessions. Thank you, everyone, and enjoy the rest of the day.